Hello everybody and welcome back to our studies in business law and practice for the SQE specification. We're moving on now to another major topic within the specification. This topic concerning specifically various issues around company decision making. So this idea of company decision making, the idea of the company's officers, the decision making of shareholders, begins by thinking about the idea of the duties and responsibilities of directors. Now, in basically ascertaining this information, we're going to find ourselves looking at various different aspects of the models of articles of association, which are the sort of standard bearer, the standard practice that most companies will use and operate by. We'll explain what the model articles of association are, and we will then think about some of the details of this particular aspect of the model articles, specifically looking at Article 3 in this lesson specifically. So the model articles of association are found in the company's model articles regulation from 2008, and they're essentially a really handy and useful way for often small businesses or businesses that don't need to have too much in terms of the complexity of relationship between directors and shareholders and all this kind of stuff in their constitution. Because there are default articles of association which will apply to all companies unless a company specifically adopts their own bespoke articles of association. They adopt their own version of their articles of association. Now, Part 3, Article 3 of these model articles sets out the powers and the responsibilities of directors of a company, and we will talk about that in this lesson here. So, fundamentally, Article 3 looks a little bit like this. It says, subject to the articles, the directors are responsible for the management of the company's business, for which purpose they may exercise all the powers of the company. That's a pretty broad and pretty all-encompassing power that is given to the directors of a company. Article 3 is a statement that essentially gives directors broad authority to, in other words, just run the company, subject to any restrictions that may be found in the company's articles or may be found in law, for example, in statute law or within the common law. But let's break this down a bit more. So, subject to the articles, this means that the powers of the directors that are found under Article 3 of the model articles are not necessarily absolute. They are constrained by any provisions of the company's own articles that limit or regulate their powers. So, for example, a company's articles of association might, for example, reserve the right for certain decisions on the issuance of new shares or maybe on issues concerning major capital expenditures that they may need to be approved by shareholders. And we will also see in future lessons that there are often decisions that are made that are found in the model articles that also requires certain decisions to be made through things like special resolution or through the use of decision making as a power that is granted to shareholders. And so in those sort of cases, those kinds of constraints will trump the general authority that is conferred in Article 3. It also means that if the articles include any additional restrictions or carve-outs, the directors must also comply with those, as well as with the restrictions that are found in Model Article 3, or the powers that are given in Model Article 3. The effect, then, of this power is that Article 3 of the Model Articles of Association gives what it could be described as a default baseline of authority, a sort of default that is given, but the company's own constitution may be able to modify, may be able to restrict, or even may be able to refine that baseline. The next part of Article 3 refers to the directors being responsible for the management of the company's business. This phrase establishes that the directors will collectively or individually, depending on the articles, have primary responsibility for running the business operations of the company. This usually involves, in practical terms, things like the day-to-day strategic decisions, operations, employment issues concerning finance, for example, all of which would generally fall into the quite broad category of management, and hence therefore be handled by directors under their authority. This is not to suggest that a director has to deal with every single issue. They may delegate that power, but that the directors are responsible for that management. And what this underscores is the separation of powers that we see in corporate governance. You have, for example, shareholders or members that can delegate or can allow directors the management function, while also the reserving of matters for constitutional or fundamental importance to themselves. So, for example, through things like a special resolution, something that we will get to in a future lesson. The final part of Model Article 3 refers to the purpose that they may exercise all the powers of the company. This basically gives directors all the powers that the company itself possesses, so long as those powers are not explicitly limited or excluded elsewhere in the articles or elsewhere in statute. And so in broad terms, a company as a legal person can do whatever its constitution and whatever the law permits. So whatever statute law, the law that we often refer to there is, of course, the Companies Act from 2006, or maybe the Corporate Insolvency Act. But under Article 3 of the Model Articles, directors are vested with the capacity to exercise those powers. A company is a legal person, it's a person in law. That means that a company itself, absent any members of the company, doesn't have the free will or the ability or the conscience to be able to act out decisions. And so directors are vested with the capacity to use those powers, the powers to enter into contracts on behalf of the company, to borrow on behalf of the company, to dispose of assets, to incur liabilities in the furtherance of the management of the business. This point, however, is still subjected to the articles and subject to statutory limitations as well. So the limitations that we see on statute that we find in the duties of directors, for example, or that we will get to also in future lessons, the various different duties that directors have, that will be looked at in a different topic. I want to just very quickly finish by looking at the relationship that that Article 3 will have to other parts of the Model Articles of Association. The reason for this is because we're, of course, going to be exploring some other parts of the Model Articles of Association in this series of lessons. So, for example, Model Article 4 refers to the members' reserve power. This article allows shareholders or members of the company to override or to direct directors by way of special resolution. They may direct the directors to either take a decision or maybe refrain from making certain decisions, and so this is an authority that is granted in Part 4 of the Model Articles. Part 5 of the Model Articles refers to the power of delegation. Directors may, subject to the Model Articles, delegate any powers that is conferred onto them, that is conferred, for example, by Model Article 3. We noted this already in earlier slides, that because a director has the ability and the power to manage the operations of a business, means that they have quite broad and extensive power and authority. One of the things that, of course, is going to become problematic is if they have to themselves, as an individual person, deal with every single aspect of company regulation, especially when it comes to quite large companies. And so, while they have management authority, they also have delegation rights. They can delegate various different powers that are conferred to them, to other persons, to committees, and so to essentially divide the work up, if you will. Part 6 deals with the issue of committees to which powers are delegated specifically. So Part 6 flows directly from Part 5 and essentially provides rules concerning the powers that these committees may have, that they must follow procedural rules that are derived from the articles, and also the directors may take procedural rules for committees, for example. Part 7 refers to the decision-making when it comes to directors making decisions collectively. These regulate how collective decisions are made, either at a meeting or through written resolutions. Part 8 refers to issues concerning unanimous decision-making. And then finally, Part 15 of the Model Articles requires the directors must keep written records for 10 years of any unanimous or majority decision that is made within the corporation itself.